It's Rick. It is, let me double check. It is October the 26th. It's 2018. And I'm happy to say you can reach me by sending me an email to Rick, R-I-C-K, 0327 at me.com. All right. And let me make a statement here, which I normally do after I do this, because the only way I can communicate with you guys. There are people out there who I've communicated with in the past who I think of as friends. Hey guys, where are you? When I make these declarations, it wasn't meant for you guys. You guys, if I spoke with you in the past, there's no reason why you can't continue to email me. It wasn't like I didn't want to hear from you guys. Normally, when I make my declarations, my policy is I just don't want people who've never given me a gift, or just looking to pick my mind for free, or send me these super duper long emails ranting. Okay, I'm not interested in that. All right. But there are many people I've become friendly with who are, I guess you consider friends. I consider them friends, and I don't hear from you guys anymore. And if I scared you away, I apologize. Okay. Um, Running this channel can be very stressful, and sometimes, um, I may say things in frustration, and I don't mean to. Okay. Definitely. I'm definitely a human being. I definitely have a lot of things wrong with me. All right, I'm not perfect. All right, I'm definitely far from perfect. Yesterday I spent the whole day in the hospital. Remember I told you guys I have high blood pressure, very high blood pressure. I had to take a break from the channel in the month of June. My blood pressure was up 240 over 160, which is dangerous to say the least. Um, and a lot of it was from running the channel. You know, I tend to take this serious. You got to remember this is my paperwork. All right, I created it. They're my babies, and when I send it to you after you send me a gift, from the bottom of my heart, I want all of you to win. And when I get emails, and I'm going to be honest with you guys, most of the emails I receive is bad news. All right, it's bad news. I rarely get good news. So picture, every day opening your emails up and you get nothing but bad news. So it affected me, and also I had issues with my heart, and I had to go in yesterday for a procedure, and thankfully everything's okay. All my arteries are clear. All right, and but I was, I was holed up in the hospital. They're going out of my mind. Let me see if I can show you the picture. So if anybody reached out to me yesterday and I didn't get back to you, that's the reason why. Um, but I'm doing better, and I'm happy to say everything's good. The doctor said my heart is healthy, and my blood pressure's under control. Okay, hold on. Let me see if I can find the picture. I I took a selfie of myself yesterday. It was hilarious. Look, I'm a fat bastard. I gotta lose some weight. All right, let me get rid of that. I used to be in really good shape at one time, guys. Okay, and what happened? This child support stuff destroyed me. All right, the stress destroyed me, and it sent me into a 5-year battle with depression, which I'm still fighting to this day. Okay, but I'm not going to give up, and I'm always looking for ways to help you guys win. All right, so in this video, what we're going to speak about is filing an injunction in the court. Okay, now what we're going to do is take the evidence that we have. And what evidence do we have? Well, the evidence that we have is the weapon they're using against us is this support order. Remember I told you all of these support orders are void. They're all void, okay? So we're going to take them and we're going to use them as evidence, and we're going to file a petition for an injunction, okay? All right, so by filing a petition of an injunction or for an injunction and using the evidence of the support order and the income withholding order. The income withholding order is also void, okay? And it's because it's being issued by an agency that has no judicial powers. It's a clear violation of the separation of powers doctrine, okay? Try to explain that to the employer. What they do is they scare these employers, and my experience is the employer, they don't care. They just don't want any hassles. They're too busy trying to keep their heads above water dealing with their business, and they don't want to fight another battle, which is your taking money out of your check, which is really bad. Okay, they should try to keep their workers happy, but my experience is they just go, well, we're just going to send it anyway because they don't want to be bothered. I have had people, I showed you guys a video like a month or whatever back. There are employers that do honor the cease and desist we send. Okay, so there are men. Also, we had guys who filed cease and desist in court, and when the employer was notified, the employer withdrew. And the last I heard, everything's still going good with that guy. So hey, that's good news. All right. So we're going to file an injunction. Okay, so I said that before. We're going to use their evidence of a support order created in violation of due process, and it's an acceptable reason to avoid a judgment on the Federal Rule 60B. Okay, when filing a petition for injunction, you will enter as evidence the support of petition. Okay, in support of petition, see, that's why you got to use commas. Okay, that's why commas are very important, guys. So when filing a petition for an injunction, right, comma, you will enter as evidence, comma, in support of what? The petition. In support of the petition, a support order entered as evidence. I already put that, okay? A support order, there we go. You will explain in detail in the petition the reasons why a support order is void. And we're focusing on the expedited processes. See, what allows them to get away with these proceedings is this expedited processes under 45 CFR 303.101. Now, and remember, I did a video recently, and the reason why they get away with it is it is added a line. Well, they got to safeguard due process, but they don't explain how. And it's up. So what it is, it's a presumption. So they're getting away with that. That the presumption is they gave you due process, and it's your job now to file an objection. It's really horrible. Okay, and that's the problem we're coming up against, is because we're coming up against these judges in the court who are supposed to judicially review the evidence and make a finding based on evidence and facts, and they're being dismissed. I recently had a guy show me paperwork, the real Mike Cowell, and he filed paperwork, and what the judge did was pull a slick move, put down findings of fact. Now, we use multiple facts. We use adjudicated facts, and facts of law. And what the judge did was pull a slick maneuver by just citing one fact from the pleading, from the paperwork, and it was a very benign fact that didn't, cause the judge to have to do really anything. He just cited the Supreme Court decision of Howlett versus Rose, and then still dismissed the paperwork while disregarding all the other facts. This is the type of stuff we're going up against. All right, because my paperwork is really strong. I box these people in, but they still resort to tricks. which is, important that you try and get a hearing. Try and get to stand in front of these people and hold their feet to the fire. That's what happened to me. It wasn't until I got in front of a real judge that I finally got my case, going in the right direction. Okay? You inform the court under the 14th Amendment, equal protection of law, meaning that the law, they're supposed to protect your rights, your rights secured by the Constitution. All right? This is screenshot, all right? An injunction is a court order requiring a person to do or cease doing a specific action, right? There are 3 types of injunctions: permanent injunction, temporary restraining order, and a preliminary injunction, all right? We want permanent, okay? So, and see, now, the failure to comply with an injunction may result in being held in a contempt of court. Now, I always use this point myself, is the famous, and I said this in my videos numerous times, Roe versus Wade is the Supreme Court decision that's really causing all the problems to this day. This whole Brett Kavanaugh thing was exaggerated and drawn out with all these fake claims being brought into court, to try and block him. It's because he's a pro-life constitutionalist judge, all right? And they for some reason they want to keep killing babies in this country, okay? They love, there's videos of these maniacs who work for the Planned Parenthood who are selling organs, okay? When you allow abortions up to 26 weeks, the pregnancy, I believe it's 26 weeks, okay? I could be wrong, but I believe it's at least 26 weeks. You have a fully formed human being, okay? That means they have fully formed organs. So what they do is, from what I understand, they when they perform the abortion, they pull out a live baby, and then they sell the organs. Okay, that's what's going on. I mean, that's really, really bad. All right, I'm not getting political here. Okay, I don't know, and I don't really, I'm not looking to hear in the comment section, people's political view. That's just my political view, but I'm just telling you that that's a famous case. Now, if somebody was to tell a woman she couldn't get a abortion, they would cite, every lawyer in the country would cite this case law, okay, and the judges would never go against it. Well, any other case law, especially from the Supreme Court. Now, I like to use Supreme Court adjudicated facts because it's the court of last resort. It's the highest court in the land, and every court beneath it is an inferior court, okay? And we're still getting these judges, disobeying. They're in contempt of court, okay? That's really what's going on. They're in contempt of a Supreme Court opinion, okay? And really, an opinion by the Supreme Court is law, okay? So that's the reason why I use the Supreme Court adjudicated facts. Okay, an injunction is a court order requiring an individual to do or omit, right? That's what we want, doing a specific action. It is an extraordinary remedy that courts utilize in special cases to alter or maintain the status quo. What's the status quo? Well, the status quo for us is that under the Bill of Rights, our status quo is our property is protected from search, and in our case, seizure, okay? That's supposed to be the status quo. The status quo in this country, and I've used it several times, if somebody was to knock on your door and say, can we enter the premises, what's the first thing you're going to say? Do you have a warrant, right? We've seen it on television, all right? And those of us who study the law, we know this. So where is the warrant to take our property, which is our income? I was watching a show last night. It was a great point. Your labor is your property. Think about that for a second. The 40 hours, let's say, I'm just saying 40 hours in a regular work week. You give 40 hours in a work week, that is your property. Okay? And no one is allowed to seize your property or a percentage of your property. That's what they're doing. They're seizing a percentage of your property by some child support agency issuing a fake order that looks like a court order, looks just like a income execution order, which is an actual order from court. If you were to take an income withholding order and compare it to an income execution order, it's amazing. They're very similar because the income withholding order is a forgery. Okay? It's a forgery, in my opinion. Okay? Now, don't go, citing that in your paperwork, all right, unless you can prove it. Okay? All right? An injunction is an equity remedy, as such available in cases in personam jurisdiction, in rem proceeding. Now, by the way, in personal jurisdiction, that is also the Burnham versus Superior Court that says these persons not judges, quorum non judice, they are without personal jurisdiction to take your personal property by issuing a judgment. That is exactly what that case is about. It's really about one state claiming it has jurisdiction, or let's say your body is in one state, and let's say, like, all right, you're like me, I'm in New York, and then the state of Florida telling me that they have jurisdiction over me, even though my body is in New York. Okay, that's what they're talking about. But in the opinion, it says that the judgments are void in violation of 14th Amendment because the person not a judge, quorum non judice, the judicial authority was not present. Okay, does that sound familiar? Yeah. So they know that, right? So how do they get around that? Well, they give you a proceeding that looks and sounds and acts just like a court proceeding. Your Honor, all rise, raise your right hand. All of these semantics that make you think you're participating in a judicial proceeding when you're not. Okay? All of these things that they do to trick you. Then the income withholding order looks just like a court order, right? And then they use that, they send it to your employer to trick your employer. All this trickery. Okay? So that's why, we have on our side knowledge. We're using our knowledge, okay? So we're going to move on. This is what mine looks like. Notice of petition, injunction to protect the seizure of property in violation of due process. Okay, that's what mine looks like. All right. Chapter 6 of right here. The essentials for attorneys and child support. Very, very important. What do you call it? They're basically instructions. There's 12 chapters, and they basically tell it's a rule book for them. All right, and what this is chapter 6, and what's slick about it, we're talking about expedited judicial processes. They talk about advantages and disadvantages, and they gloss over that the child support order is void because right here. They talk about the emergence of administrative process. States have taken alternative routes in fashioning their expedited processes. Several jurisdictions were pioneers in this field. Now, what happens is they enter a judgment against you, but it's your job to file an objection or to get a judicial review. Remember, I mentioned in my other videos that I use New York all the time. Obviously, I'm from New York. And in New York, under the Family Court Act 439, it says the order from a support magistrate without the confirmation of a judge lacks legal force. What's the judge? The judge is the judicial review. And what happens is when you file an objection to the support magistrate order, where's the objection go to? It goes to a judge. It's the judicial review. You see how they hide these things? And in New York, they pull this nonsense that you're not allowed to file an objection until after the support magistrate issues the order. That is completely unlawful. Okay? That is their procedure, but it's unlawful. Okay? All these little tricks that they use against us. Okay? So, getting back to it, the constitutionality, the movement from judicial processes, CSE, to administrative processes has raised issues of constitutionality. The main one, the separation of powers doctrine. Okay? An income withholding order is a complete violation of separation of powers doctrine. All right? The Supreme Court of Minnesota recently held under cited 34, 1999, that the administrative, another thing they do is, let's say you are a married person with a divorce. These child support referees, we'll call them, the fake judges, they are not allowed to touch your divorce agreement. They have absolutely no legal power to alter your agreement. They do it all the time. They claim they have the power, but they do not. And this is the law that the case law, Holmberg versus Holmberg, that says basically that the administrative process infringed on the district court's jurisdiction, the judicial review, in contravention to the Minnesota Constitution. A lot of it has to do also with the state constitution. They get crazy with the words, all right? Also, it's the constitutionality, right? The due process raises fundamental federal protection. The 14th Amendment provides that a person shall not be deprived of life, liberty, or property without due process of law. And that's exactly what they're doing. Okay? So let me get back to the slides real fast. Okay? This is the, right here is the URL. You can cut, and I don't know if you could do it from my video, but you could write it down. Or you could just keyword expedited processes, okay, in the Google search, and that will come up, okay? All right, we just went expedited processes, expedited judicial process are systems in which judge surrogates, you know what judge surrogates are? Fake judges. Make judicial decisions, which that's a complete oxymoron. They're not allowed to make judicial decisions. I gave you the case law. Burnham versus Superior Court, okay? Judge surrogates are referred to by various titles, including masters, referees, commissioners, right? Magistrates, hearing officers. The decision-making occurs within the traditional judicial system as an extension or tier of the court, okay? They're fact finders. They examine evidence, take testimony, and enter findings or make and then they're supposed to pass it on to a judge. And then the judge is supposed to make findings, even though that's, to me, unlawful as well because the judge was not present. So it's basically hearsay, all right? Okay? Advantages and disadvantages, okay? So what I'm going to do now is I basically covered everything what I'm speaking about as far as the law is concerned, all right? I'm going to show you the slides, okay? And that way you guys can look at it, right? And study it, okay? Here's the thing. Child support obligations can be established more quickly. That's the advantages for them. But it's a complete disadvantage for us because it's not legal, okay? All right, advantages for us. I just went over it. The constitutionality. Okay. The Minnesota Supreme Court case, Holmberg versus Holmberg. And they cited under the due process and the constitutionality, okay, 35 is the citation. If you look down here, 35 is federal regulations, 45 CFR 303.101, subsection C2. Okay, which is proof that they must follow due process. We've defined due process. How do we define due process? I use the case law from the Supreme Court. Murray's Lessee versus Hoboken. Okay, that says due process is the law of the land. Okay, the law of the land is the Constitution. The Constitution says that, oh, I got to show you guys something very important, that you are entitled to a trial by jury. You cannot have your property taken unless by a judgment by peers. Okay, so check this out. Okay, right to the nose, person has to be notified of any action being taken. Okay, how many of you out there have not been notified? What they do is they drop it in the mail. Okay, right to a hearing. Again, you guys can read this on your own. Okay, you have a right to a judicial review of every administrative action. That's why Rick, what do I do? That's why I tell you guys to file an objection. Okay. Holmberg versus Holmberg. Judges who had the power to set child support awards and to modify awards previously set by circuit court. The orders were directly appealable to the appellate court without review by the district court. Okay, what they were doing was they were jumping over the district court and going right to the appellate level. That was a violation. Okay. Okay, this is how, now, how many times have you guys heard by these people, we do not have to give you a trial by jury. You want to know why? They do not have to give you a trial by jury for a paternity matter. Why? Because in paternity, they are not depriving you of property. They are establishing a fact. Okay? So this is how they deny trial by jury, but as usual, under false pretenses. But now you know to object and cite this chapter. Okay? So when they say you're not entitled to a trial by jury, that's only in matters of paternity, not for money judgments. Okay? This is very important. Okay? Very important. Okay? Conclusion. That's their conclusion. Citations. All right? This is the chapter. You guys can look. Okay? And that's basically it. Okay? I'm showing you guys how, why we're entitled to filing an injunction, and how, if we use our support orders, how we can explain how they're not constitutional and how they violate due process. Okay? All right, guys. Thanks for watching the video. I hope people learned something. Enjoy the rest of your night. Bye.